Adjournment request, if any, from item number 1 to 11.
Number 4 and 5.
4 and
Yeah.
5.
On behalf of Harish Gupta, he has undergone surgery yesterday. So, and we have circulated the 4 and I think
4 and 5 adjournment slip circulated.
Oh, yes, ma'am. All.
Have you informed the council for?
Yes, ma'am.
All right. 1, 2, 4, and 5. Adjournment slip has been circulated.
1 to 3 and 4. Date 25/6. 25/6. All right. Item number 12 to 20.
Vijay, adjournment slip in item number 4 and 5, or number 1 and 2, since they are analogous, they shall also be listed. Yes,
Consider the petition objection is mentioned item number 12, my lord.
item number 12.
Take it after
Adjournment slip has been circulated. All right. Take the date first.
22nd June. Item number 22 to 47.
Item number 44.
44.
Yes, question.
All right.
Applies.
My lords, if I may mention item number
Just a
45.
minute. Yes,
Item number 44 by name has been shown, so it now can be deleted, my lord. Because the case is belongs to Mr. Saikia and it will be argued by senior counsel, Mr. Gustavo.
किसका नाम इनका लिखिए. Adjournment slip has been circulated. Let this matter. Henceforth, name of Mr. M.U. Mahmood, learned advocate, be removed from the array of advocates appearing for the parties.
On 16/7.
Yes,
Please, Lordship. Lordship, I beg to mention item number 43, Lordship.
all.
In the 16th of June, Lordship.
Hmm?
16th of June, Lordship.
We don't settle for dates like that. Leave it to us. You can make a request for sometimes in May, sometimes in June, but date would be according to our calendar.
Yes,
23rd June.
No,
Obliged.
is that too late for you?
Obliged.
Is it okay, or we should prepone it?
23rd of June.
All.
Okay.
Yes.
My lord, if I may mention item number 45.
We're sorry, Mr. Silo, we will not be able to accommodate you today. For the reason that this matter has been argued in detail, and we have given you adjournments on your ground, you were on legs, or you were busy somewhere else. But then, it doesn't look good to see an order sheet where there are more than 5 adjournments. We normally do not refuse adjournments on the ground of the advocate, but I think the entire matter has been argued.
My lords, if my lords may kindly hear me, this is only the second time that I've asked for time, my lords, since the previous occasion, my lords.
As prayed for on behalf of the appellant. But please remember that next time onwards, next time we are not going to grant you any time. I think we have almost dictated our orders. Of course, on one of the issues, you had to file certain documents. In your favor.
He has to file
My
some
lord.
affidavit.
As prayed for on behalf of the appellant by Mr. L. Silo. Come on, the matter is adjourned to
18th June.
No. Then give it in August. Finish off all
6th August.
your responsibilities, and then in August argue this case.
Obliged.
My lord, my lords may kindly reconsider, my lords. My lords may fix this in the month of June, my lords. My lords may kindly reconsider,
Very well in June.
my lords. Oblige, my lords.
18th June. From item number 49 to 56.
No, we consider other side, petition number 49 and 50, my lord.
All right.
In this matter, can I pray for a day upon the 9th of June, my lord?
9th of June. You are for the respondent in both the matters?
Yes, ma'am.
Ninth accused. Obliged.
Item number 52.
Yes, examiner slip has been circulated. All right.
All right.
You like.
23rd July.
May I please, Your Lordship, with the consent of others, that item number 51, kindly adjourn this matter for the day.
Item number 51.
Some instruction is awaited, my lord.
You have been dismissed. Is that the case? Dismissed teacher. Why do you want time?
Some instruction is awaited, my lord.
As prayed for on behalf of the appellant, re-notify July.
Obliged.
28th July.
May please, Your Lordship. But I seek your Lordship's permission to file and move an appeal pertaining to an order passed by the Honorable Single Judge in Itanagar Bench, Miller. Since the Honorable Single Judge is sitting in the Division Bench, Miller, and there is an urgency in the appeal, Miller, may I pray for allowing me to file here, Miller, in the principal bench
I think we can.
and listing, Miller,
Yes,
on Friday, Miller.
On it.
Grateful, Miller.
Friday. Yes.
Grateful, Miller.
Any other request?
Yes.
May I make a prayer, Milan?
Yes, Mr. Bodpatra.
Well, at item 10, I'm engaged there in Milan, but I have got some visionary problem, Milan. I have to put injection tomorrow, Milan.
Item number 10.
Item number 10, Milan. I have completed my line at 10 also. So may I pray
There
that-
is no difficulty, Mr. Bodpatra Gohain. We will be delighted to hear you. But then this item is listed along with 8, 9 and 11.
Milan, he is there. My senior friend is there.
Appear for the appeal.
All right, when do you want it?
Yeah.
Give us a date, because this is very important. This
Yeah.
is mandatory application of UGC rules,
My lord,
correct?
my lord.
So I don't think we can delay the matter for any longer.
No,
And
no.
it has been it has already been decided in a case from UP
My lord,
by the Supreme Court. Please have a look at it.
my lord.
I am aware of it for the reason that I have dealt with this matter in another jurisdiction. The applicability of UGC regulations, even when they were not available
Yes, ma'am.
earlier. So this is what the Supreme Court has to say, that this is a national regulation which must govern so far as the academic excellence is concerned.
That is the issue, man. That is the issue.
That is the issue. Therefore, I think you have a judgment of the Supreme Court which cannot be derogated from.
My lord.
So you'll have very little space of argument unless you say something else.
Yes, madam. We'll try our best, madam.
So these are cases where the decision making is very easy. No? The law is very clear.
Yes.
It applies. It
Yes.
applies with full force.
At least-
Like trying to satisfy your worship, my lord, it does not apply unless adopted, and adoption has not been there in the state of Assam. And there are affidavits, my lord, where they have said that.
And that's one limb of argument which can be considered. We'll see. We'll see. When?
Your worship, give a date, convene to your worship.
Subject to your lordship's convenience, madam.
July? As prayed for on behalf of the appellants in all these cases, let these set of appeals be listed
20.
under the appropriate heading on so and so date in July.
23/7,
23rd
23rd July.
Month.
Any other request?
Master lord.
Daily list for orders item 6 and 7 along with item 58 of supplementary list.
Yes, what is the interim order?
Lord, your lordship was pleased to pass an order. Sorry, sir. I'm so sorry.
Where is the order which is required to be modified? What is the confusion, Mr. Chair?
Sorry.
Yes,
Similar, there are two IAs.
yes.
One, I think, in person, the gentleman has filed.
First, let us see the IA. First, let us see the order, our order.
Yes, yes. Yeah, please.
Page,
11 to 26 order. Mr.
page,
1 second. 11 to 20 order. Page 33. It's no, no. 33. 11 to 24. 11 to 11 to. My lord,
Please, amicus.
in one case, I am amicus. And another case, I have also filed an IA on behalf of the school. Page 33.
Just a minute. Yes, you're the principal owner of the Gurukul Grammar School. Just a minute.
Your Lordship,
No,
I am
yes.
present for Northeast Eco Development Society as its secretary, and I am the original petitioner of PL number 14/.
What do you want?
May I please?
What do you want?
Your Lordship, I have filed IA Civil 1521.
Leave the number. What do you want?
My prayer.
That's all right. But what do you want? We want to know from you orally. You have come to appear personally.
Petitioner in person.
Yes. What do you want?
It says.
Mr. Das, help him out. Is he understanding what the court is saying?
No, he prayer to video. New developments.
Huh?
New development. New prayers. Prayer to he is a video. He prayer as a video. Lordship, may I please shed some light on IA Civil 1521/2026? Learned Advocate General had spoken on the long-term measures taken up by the Government of Assam, Department of Housing and Urban Affairs, and how the people of Gauhati will be benefited by 183 crore.
All right, we are taking care of this. Don't worry. We are taking care of this. We'll be getting an updated affidavit on behalf of the state. Some surveys being made. And everything is under process. I thought you were representing the school where the construction process has been stopped.
Lordship, the original application was regarding illegal hill cutting activities going right under the nose of the divisional forest officer, East Kamrup Division, Basista. And also how far the natural river system of Gauhati has been made encroach free by the Government of Assam, Revenue and Disaster Management Department. We have made
You
investigation.
please watch the proceedings. We will not make it, multi-pronged. The issue is such that it requires very focused attention. Correct. So what we propose to do is that we will keep this on record. We will also ask the state to respond to the IA.
Okay, sir.
Correct. And we'll deal with it while we are dealing with the PIA. I think that will serve your purpose. Look here. Yes, that's all right. Which is the second IA?
Yes.
We are going to pass that order. You can take your seat. You can take your seat anywhere. You can go and sit there. There's no difficulty. We are going to pass an order indicating your presence and your prayer. Sit down. Yes.
1261.
1261.
Yes.
Yeah. 1261 कहाँ है? Yes.
Yes.
Hmm.
If your lordship would kindly come to page 46 of that IA, my lord.
Yeah.
There are two aspects, my lord.
Hmm.
Construction of building and construction of boundary wall.
Hmm.
Now, page 46 is the planning part permit, my lord. In respect of the building given by the Gauhati Metropolitan Development Authority.
No, if there are no permission for making any construction, we are not
No,
inclined to.
it's not that. It's not that. I'm coming to it.
But Mr. Chaudhary, you are for a bigger cause. We have appointed you as a amicus.
So that is what this brief I am holding from March prior in point of time, my lord.
We are not questioning your standing and your propriety in appearing before
Yes.
it. But we would like you to focus on bigger aspect, not this. We are not questioning your propriety. You can. Even if you are not engaged in that matter from before, we will not stop. And this is not our approach has never been that. Lawyers can always argue.
In fact, my lord, the other PIL, when it was filed, I was not there. In fact, my lord, I presented the newspaper cutting before the court number 1. Based on that, it was done.
Correct.
And I was requested to become the amicus, that's all. And my lord, in
And
that
we retain that position and we
Sure,
request
sure.
you to remain in amicus.
Sure,
And
sure.
you did a good job on the last occasion when we framed all these
Yes.
orders and the issues. Correct.
In
Anyway,
fact, my lord, I was
let
supported.
Mr. Das respond to your idea.
Yes.
Perhaps because your lordship was pleased to pass the order after considering the affidavit filed by the government.
Respond, no?
I'll respond, my lord. I'll respond at the same time.
We are not passing any order modifying
I
the order.
understand. I understand, my lord. I'll respond. At the same time, my lord, state will also respond to this IM, my lord, because they are the custodian of the records, my lord.
Correct.
So that's why.
State will respond to both the
My lord,
IAs.
only
Take it up.
there are 4 infirmities has been noticed by the GMC authority and one by the soil conservation department. Yes.
Then we'll have a clearer picture.
Yes, but the thing is not, lordship will give a shorter period.
Mr. Das, please ask him his name. Your Vishwajit Saikia. देखिए IA number 1521 of 2026. Mr. Vishwajit Saikia. Secretary of Northeast Eco Development Society has preferred the instant interlocutory application, seeking intervention of this court and direct the Commissioner and Secretary to the Government of Assam, Department of Housing and Urban Affairs, to submit a detailed affidavit on whether the drainage master plan prepared under the Assam Urban Sector Development Project shall include rejuvenation of Bahini River by freeing its banks from the encroachments before any construction is carried out on either of the banks of Bahini River. And also for a direction to the Chief Conservator of Forests, Central Assam Circle, Basistha, Gauhati, to submit a detailed affidavit on many forest officers having been serving in the same district for more than 5 years. Now, you limit your prayer to number 1. Now, this is a separate cause of action.
Yes.
And usko cut le. And also for a direction to the Commissioner, Gauhati Municipal Corporation, Ganesh Puri, Gauhati, to submit a detailed affidavit on the timeline adopted for a scrapping and desiltation of the drainage and the steps which have been taken regarding barricading of open manholes and construction areas during rainy season. And also inform this court as to the standard operating procedure issued and steps taken to effect the same. We may note we may note that in the main PIL, this court has passed an order on 11/2/2026, taking note of the situation which has caused artificial flooding in the city of Gauhati and the steps taken by the state to arrest the same. This court has also addressed the issue of cutting of hills, which has exacerbated the problem of artificial flooding. Affidavits have been asked to be sworn by relevant officers of the government regarding the steps taken in this regard. However, for the sake of clarity, Mr. Nath, learned senior government advocate, is directed to respond to the prayers made on behalf of the applicant in the aforenoted interlocutory application, bracket IA number so and so, and file a detailed affidavit by the next date.
Some scientific short-term measures should be taken regarding this.
Will
Not
be-
this typical Milan
No, no,
moving the, I mean,
that's right. That's
some
next.
scientific way of.
Mr. Ken Chaudhary,
Something.
learned senior advocate, and amicus in the present PIL, has also prayed for by the IA number so and so modification of the order dated, modification for the order dated 11/2/2026, so far as it pertains to the stoppage of any construction in Gurukul Grammar Senior School till the time the matter is finally heard and disposed of. Stop. This prayer also requires to be responded to by Mr. H.K. Das, learned senior advocate, on whose intervention such an order was passed, and the state. Stop. Let affidavits in that regard also be filed positively by the next date. Re-notify. What is the date fixed here? Today you are wearing two hats, so therefore your scientific, your scientific.
Let me make one point.
We are very clear. I mean, try and understand what we are saying. Today we are not.
This matter can be separated from this one because it's an individual case.
Correct. Today we are not indicating anything about these scientific measures, and
Yes.
we are concentrating more on desiltation and scrapping, because this is an immediate step which has been taken. Now that scientific measure is a long-term measure which we will insist upon.
So even scientific short-term measures could also be there, Miller.
There could be. We have asked, the Advocate General had agreed that he would be filing an affidavit. We have 2-3 weeks more. 2-3 weeks more. Let's see who heads the forest department and the urban development and civic ministry, who holds it. Then we will hold him responsible and we will ensure. List on so and so day, July.
July 27 July.
Much obliged. Let it be called up. Let it be called up. Mr. Nath, be here. Be here.
15 July.
I think even in June, Miller.
June would be too early. We are absolutely full with Operation Blackboards and all that.
First week of June, July.
First week of July.
Vacation.
Immediately after the opening,
Yes.
15 July.
15. Highly obliged.
So far, the item number 61 is concerned. On last occasion, also they pointed out the specific that so far the menus are concerned, which required immediate measures to close down.
We have not taken up your case now.
It is tag follow.
Take together.
Actually, it was along with this.
It is allowed.
61, yes. What do you want to say?
I have,
Last occasion, Lordship, I have specifically pointed out about the open manholes, and Lordship has pointed out that the measures has to be taken, the report has to be submitted before this one.
Yes, Mr. Nath.
I have received the report. They temporarily, they have, there is no open manhole as on today. They have,
No. This statement is not based on an objective, assessment.
No, they have either, they have,
How can you make that statement, Mr. Nath? Ask your officer who has given you this
no,
information.
they
If you
have,
find any manhole open, it'll be perjury.
they have barricaded, they have barricaded.
In front of my house.
Even my line also, my lord.
You want more proof.
In front of my.
The statement made by the officer who has instructed you is incorrect, blatantly wrong.
Kindly,
Do you want any other interjection? When the judge hearing the matter
Yes.
says that in front of his house, the manhole is still open.
they have
My area is also like that.
barricaded. I'm told that they have barricaded. I'll definitely take the instruction. I'll definitely take the instruction.
Please come up with correct information, close it till, we would not brook of any dereliction in this regard. If we find any report, even in newspapers, that anybody has died because of open manhole, we'll immediately revive this petition and then we'll ask the person who has sworn the affidavit or who would swear the affidavit.
Definitely. I'll take definite instruction.
It's not something big that we are asking you to do.
Lots of-
Close the manhole now.
Yes, sir. Watch. In fact, the written instruction, I'll file the affidavit.
It would be a matter of great shame for all of us
Lots of-
if people die just walking into the manhole. You are not able to arrest the artificial flooding in the city. At least close the manhole. Don't create
They have-
death traps for everybody.
They are taking steps and they said that they have
Good.
barricaded.
We
They have
appreciate
barricaded.
that they are
They
taking
will
steps.
finish it. They will
But
do
that statement is patently wrong.
Logic. I'll
Please find out and let the officer who has informed you be more serious about his contention.
I'm told that they have barricaded and they are doing it. I'll
Barricading and closing are two different things.
Logic. That's
Barricading, they'll try and barricade. It's a stopgap arrangement. They'll put 4 sticks,
Yes.
which will fall down because of the flowing water.
that's
Temporary measures.
Experience.
definitely.
Two men, one day dedicated with 3-4 bamboo with some plastic.
Yes, ma'am. This situation is happening.
The other, which is still open, the family whose house is nearby, he has that on his own. He's doing, I have seen today that he has called me that the carpenters and all they are.
We are serious on that. We are taking steps. Definitely we'll take steps.
My lord,
Next week,
Toughen. Logic.
my lord, if look into my prayer part entry, my lord, respondent of 5 to 7 are concerned because there must be a composition of my lord, the PWD, GMD, and
wait
DNC.
next week, Mr. Chamaria.
Sorry.
Don't make it a personal vested interest litigation.
My lord.
Now, we want it for all,
No.
not only for the manhole in front of your house. So therefore, don't ask
No,
for
no,
any
absolutely.
directions. Let him respond and then we'll say.
My lord.
Logic.
Okay. Let this PIL number 36 of 2026 be listed on. When I need a definite information on affidavit,
Follow.
at least in the city of Gauhati,
Yes.
we'll ask you to extend it to other places also.
Malad.
But in Gauhati, I think all should be closed.
Logic.
Next week,
brokers are they are replacing. I have given a data. I'll file the entire data and entire affidavit. Next week.
we are not interested in affidavits.
No, they are doing.
We are
they
interested in knowing whether you have done the needful. or
working.
not.
Yes. They-
Whether you have taken the requisite interest in the matter.
Logic, take up this.
And who would be the main person? The chief municipal commissioner.
Chief engineer, PWD, chief engineer.
No, chief municipal, forget about engineers. Who would be in the bureaucratic setup, who?
Commissioner GMC.
But chief municipal commissioner hota nahi hai na?
Commissioner Guwahati Municipal Corporation.
Commissioner Guwahati.
And
Ask him to remain vigilant. This court can call him anytime. Correct? So we don't do it normally. But if you force the court to do that, then we'll not shy away from doing it.
No, Lordship, may not require, we'll do that. Lordship, keep it after 2 weeks.
We are not saying anything. Let this
Intervene
matter
time.
come up for
One.
consideration on after. Okay. On 25th of May, well, by which time Mr. Dipankar Nath Lanet, senior government advocate, shall file an affidavit with regard to the covering of all open manholes in the city of Gauhati. Deeply.
Item 57 for orders.
Yeah, yeah. You- Yeah. What is this matter about?
My lord, this is regarding, my lord, the petitioner's appellant service was provincialized the year 2015. Then, my lord, there's benefit of provincialization has been withdrawn by the department. Then, my lord,
Let us see the order.
yes, the order improved here, my lord. At page, my lord, 157.
Yes. Which paragraph?
Yes. But, paragraph, my lord, 13,
Yes,
page 162.
yes. Read the paragraph.
Yes, at this stage, Mr. Katuniya Lanet, standing counsel for the education department, submit that the Lanet single judge has committed an error in giving benefit to the respect of the provincialization under the Act 2011, which was subsequently struck down by the division bench, and therefore the respondents can be provincialized only based on the criteria under the Act 2017. Then, my lord, we agree with this submission inasmuch as the service of the respondent are yet to be provincialized under the Act 2017 and not under the Act 2011. Therefore, the consequential benefit granted by the learned single judge is required to be granted to the respondent under the Act 2017. Then, my lord, with the aforesaid observation and reasons, the impugned judgment and order dated so and so.
Have you filed your affidavit in response to this application for modification? I think we are not going to modify this. You would be entitled only from 2017. Not from 2011.
Now, since our service has been provincialized under the 2011 Act, in the year 2015,
You are good with, and I specifically pointed out in 2017, there is a provision how these people will be dealt. Specific provision under 2000.
No modification. You can challenge this before the Superior Court.
now section 24 of the Act make it clear, 29.
For him to have a passport for a Superior
Now,
Court
it is-
ruling, you respond to this.
Yes, madam.
It is not
Have you
that
not done it up till now?
our service is going
Sorry,
to be
madam.
provincialized. Our service has already been provincialized.
Learned standing counsel for the higher education department, for education
Eh,
department,
Education department.
for
Department of School Education.
seeks one more indulgence to respond to the aforementioned application seeking modification of the order dated so and so, of the judgment dated so and so. Re-notify on so and so. Where we think you are entitled only from 2017. Doesn't require any modification or review. You can challenge it before the Superior Forum. Anyway, let him respond so that you have everything in your.
24/7.
Obligation. Can it be, my lord, earlier, my lord? That date fixed, my lord, can it?
No. Yes.
Obligation.
Next.
Item 59.
58. 59 would now.
May I please, your lordship?
Who appears for respond number 2? Yes.
This matter regarding this the IA that has been claimed that the hearing should be taken place. But the argument has been heard, but order has not been passed.
Which matter?
Lost it. Matter pertains to NCT Gauhati University.
So earlier also we filed a writ petition seeking direction of this honorable court to direct the NCLT.
Your lordship has passed. That
Earlier order is
125.
125 lordship.
Lordship, para number 16, page 129. Lordship. So after that, 6 or 7 days have been passed.
Anyway, you respond to this petition.
That date.
You respond to this petition. Again, Mr. So-and-so, can I meet him? Mr. M. Sharma, learned advocate, has appeared on behalf of respondent number 2, who submits that he shall be responding to the petition by the next day. Re-notify.
Lordship, the date before the tribunal is 19th of May, Lordship. Lordship, then
We will not say anything. Once we have said they are not doing it, we will deal with it now.
pray for the
We will.
stay of the proceedings,
Sorry.
Lordship. Lordship, then I may be granted a liberty to say adjournment before the tribunal, Lordship, because they are.
That's your
Lordship,
discretion.
now they are seeking the.
Let us not give.
Now they are.
How does
seeking
it
the
matter? Even if a judgment is passed and it is found that the court did not have the jurisdiction,
Lordship,
it will
they are
all be
seeking
known
the
as.
personal attendance of the petitioner, Lordship. This is a concern, Lordship. Pleadings have been filed. Now they are seeking the personal attendance, Lordship.
No, we are not interfering with this.
15 June. 15 June.
Yes, next.
Item 60.
If a tribunal does not understand that jurisdiction is the main issue which has to be decided if it is being contested, then we deal with it. But then we can't ask a tribunal which has all the wherewithals of a court
After the order
to
of.
decide that you don't call somebody, don't ask somebody's personal
After the
presence.
order of this court, Lordship, 6, 7 dates have been passed. They are not taking into consider our application, Lordship.
Followed it. So you let him respond. You pass an order. Let him respond. It must be at his instance. Let him respond. We will take care. How does it matter? If for once you appear before the tribunal, where is the difficulty?
Now, Lordship, they are seeking the personal attendance where the counsel is present before the
If
tribunal.
we find that there is no jurisdiction, the entire order passed by the
Lordship.
tribunal would be known as.
Lordship,
Anyway, we have our own ways of handling things.
Lordship.
We will not ask, will not direct a tribunal not to do this or not to do that. We will set right the order, we'll set right the mistake.
Lordship.
That's how we deal with it.
Lordship, in
this
this
case,
case, IRP has already filed its report.
With respect to this, that it is not being decided every time he is being asked to be personally present, just give your response. You need an early date, we can give you an early date.
Lordship, please provide an early date, Lordship.
Sometimes in June. 15 June.
Much obliged.
Item 60.
Yes.
May it please your lordship. Essentially, my lord, we have seen the order at page 175. Well, my interim prayer was not granted, my lord. However, it has a little background.
Just a minute, give us a minute. Give me a second. After our.
Yes, yes.
You want an interim.
We are praying on the merits of the order of the registrar. Initially, the board had passed an order.
You respond. No, you can't linger the matter like this. No, let's see. The registrar has done it, the registrar has done it. We have to.
The liberty was granted by my lordships
That's it.
to essay the.
We remember we have passed.
My
it.
lordship.
Okay, let notice be issued to. Hold on. Respondent's number. Let notice be issued to respondent number so-and-so, which has been accepted by so-and-so learned advocates who are present in court. Let the response affidavit to the prayer, let response affidavit to this appeal be filed positively. No interim order in the meanwhile. Don't write that word. July.
23rd July. Item 62.
Lord, in this case,
Yeah, one second. Instruction like. Yes, Mr. Sharma.
My lord, I have received instructions, my lord,
File your affidavit. Mr. Dubey,
I understand. Lord.
Mr. Dubey, all these grounds fade into insignificance. Anyway,
Well, I'll
You
try
have-
to
you have-
satisfy your
you
lordship
have
on this.
right
first.
to defend yourself.
Mal.
We will not dismiss your petition lock, stock and barrel. We'll hear it.
Mal.
We'll give a reason. And in fact, some more punishment beyond dismissal should be there. You should be kept in custody.
We'll let they file
You
response.
have brought a bad name to your police. You have brought a bad name to the state.
Lord, I'll not
If
say
something
much.
more could have been done, we would have. Anyway, let's see. You respond. You bring a girl to the police station and in the night you take her photographs. What faith would the
Lord,
department have
with all
in the
sense of
midst-
responsibility, Lord, I'll persuade your lordships. The facts that have been
distorted?
projected are not the correct one.
But what is the animus of any person in maligning you? You are a petty official.
Lord,
You're only an officer in charge of a police station. And the
custodian of-
girl has nothing against you if you had given her shelter in that night. And who is this vigilante who actually prevented her from going with her friend?
there are issues.
Has the FIR been registered against that person?
my lord, that.
Ms.
is-
Sharma, we would like you to inform. We'll
I will.
convert it into an appeal. This is appeal.
Yes, yes.
My lord, it has been, my lord, there is a
We'll
complaint.
issue necessary direction.
I will obtain. I will.
File an affidavit. Mr. Dubey, don't press it before us. We will expand this.
Lord, I understand, Lord, what has fallen from your lordship. Lord.
Crime against
It's
society.
better
my
that
lord.
you lead a quiet life if you come out of jail.
But the other sword is also hanging, Lord. That style is going up.
Why you'd be convicted? Punishment would not be less than 20 years. Which offense? Under which section of
My lord,
POXO?
that's 350.
Is this POXO or 376?
Foxo is there, Lord. Foxo 12 and
Yes, my lord, 12-4, box.
kahan bachenge aap? And you fall in the special category of saviors.
Yes. Lord, more responsibility. Lord.
Custodian of the law, my lord.
Any you respond.
I will.
Then we will admit or we will dismiss. But I will say, it is your Ms. Soumitra Sharma, learned advocate for the state, submits the necessary affidavit shall positively be filed by the next date. We notify July and August. It should be.
7 August. 7-8. Item 63.
My lords, I'm appearing on behalf of the appellants.
Yes.
The arguing counsel is on his legs before Supreme Court in a part heard matter seeking a short Passover, my lords.
All right,
Matter for time,
Two-
Lordship. After 2, Lordship.
2 o'clock.
Obliged, my lords.
Daily list, item 13 to 29.
Take it up on the next.
Just to do.
Now we have the old. These are actually all covered, my lord. There's a division bench judgment.
Nazari,
No, my lord, Sanjay,
19.
Upen Das.
no, my lord, Sanjay Kumar versus Union of India and others.
Yeah, what is-
2023.
Please argue, what is it?
2023, 3 GLT 358.
Like,
19.
And secondly, my lord, in the earlier round of litigation, the state's affidavit made their position very clear that the appointment will be prospective, but it will be counted for pension and other purposes. Item number 14 to the option.
no, tell me one thing, Mr. Chaudhary. This judgment is not being followed. Every day matters are being dismissed. Is this not being shown?
Maybe, my lord.
Every day the matters are being dismissed. And this has not been challenged by the state.
No,
Mr.
to
Borpilli,
my understanding, no.
That pertains to perhaps to the central,
So central principle is saying.
because
Now, if a lordship would kindly come to item number 14 to the option A.
19.
Amado?
19.
19. Now, there's an earlier judgment of the learned single judge, my lord. I'll just like to refer to one passage.
at number 19.
19.
Yes. My lord, this is the order which was passed earlier by learned.
You will leave the argument.
Which I don't know.
Yes, my lord. Yes.
So which will be different?
19.
Item 19, my lord.
He's appearing on in case of
No, drop teacher. Now, in one case, I'm appearing for drop teacher. In one case, I'm for obedience. Yes. Yes.
What about ad hoc?
Ad hoc, I'm not sure.
No,
If a lordship would kindly have this, my lord.
This was not shown before the electrical level.
Maybe, my lord.
no,
I was not there, my lord.
Not shown.
not sure.
No discussion on the.
if I may,
Unless it is per incurium, we'll have to constitute a larger bench.
Yes. No, my lord, the government stand is very clear. That's what I wanted to show, my lord. Please have this item number 19, my lord.
No, we'll first deal with this.
Ah.
Government stand will deal with this first. Just now you heard the tribunal goes, on different issues beyond jurisdiction. Whether we can hear this with a different view in mind.
No, my lord, as a coordinate bench, perhaps lordship will have to follow this, my lord. Or if your lordship feels that view is not.
Any other Supreme Court judgments are there?
No, even this judgment is based on Supreme Court judgment.
So the other Supreme Court judgment, what we understand, of course, it's we are always open.
No, my lord,
Nothing against the appellants.
yes,
They are always open, but we should not go wrong.
correct.
So far as principle is concerned.
Yes.
So otherwise, therefore we say, let us examine this work. Now, how do we proceed? This I have not seen.
If your lordship wants to take a, larger view of the entire matter, then lordship will fix it on it. I'll come more prepared.
No,
with all-
before that, you give us your, on all sets, you give your written notes.
Okay.
See, it's frightening to see.
No, no,
this.
but the paper book is, the issue is very small.
So this is frightening.
No.
Yeah.
Lordship will not go by the mere volume of the paper book.
So, Mr. Chaudhary, you do one thing.
Yes.
5-pager note of argument.
No, I'll
all
give
sets.
three page and no.
No, make it 5. Don't
Okay.
make it very cryptic.
Okay. Okay,
Don't make it very cryptic. Give the note. Talk about this.
yes.
Why were you not? Mr. Portpujari?
Yes. Now, my lord, here, if I may submit, my lord, the state has its own pension rules. They are claiming their benefits under. Yes.
Have understanding of your written note of argument, then we proceed on the.
Our entire argument before the learned single judge is clearly depicted in the impugn judgment itself, my lord.
So every day, I mean, I must not have passed less than a dozen orders which is against this.
This case is
Not less than dozen orders we have passed.
Then this will have to go before my lord, 3 judges bench.
In case we agree with this, if there is no Supreme Court judgment and all that.
And then my lord, what I propose to do, I'll give a.
Not applicable. Anyway, that's.
No, more particularly in case of drop teachers, government stand has been taken note of by the learned single judge. That's the most important thing. Please have a look at that one 3-line sentence, my lord. Item number 19, page number 89.
Corresponding reference, you give, we'll fix it on some
Okay.
other day.
So simply give the.
Yes.
Highlighting. And we hope that it is separately, give the relative amount.
Okay.
Otherwise, we'll have to.
No, yes, certainly, certainly.
And what about the ad hoc, who is representing, who are is representing?
Ad hoc, I am not representing.
Mr. Chaudhary, we are requesting you also see the brief of ad hoc
Okay,
and please file a note.
okay. Ad hoc problem file the
Be easier for you. Mr. Das, you are appearing.
I am for OBB.
OBB.
I'll give you a note in 1 week. With all the amicus.
A common note would be more preferable, but if you want to give your own, you can give it.
Aesthetic.
And if lordship permits, my lord, if lordship permits with all respect, my lord, the employer, that is the education department, has not filed affidavit, didn't file any affidavit before the single judge. Now, since these matters are before this honorable court, categorizing 4 distinct groups, my lord, if the education department files 4 affidavits, my lord, because they are the employer, the incidents and implications of service, my lord.
One thing is that.
My lord.
Nothing textually there is any dispute. No dispute textually every point and all, only the interpretation.
किसी का ना आई ले लो विशेष के space as well as
Let all these matters come up for consideration for final determination on your date in July. In the mean-
After the vacation, my lord.
I will take care. In the meantime, Mr. Chaudhary, learned senior associate, appearing for some of the writ petitioners and appellants shall file a short notes of argument in all the sects. Mr. Porpujari, learned advocate
I'm representing the finance department.
representing the finance department shall also file
Yes.
a 5-pager note regarding the stand of the finance department. In the meantime, Mr. Khatniar, learned advocate representing the education department, shall respond to the memos of appeal and writ petitions. As no affidavit had been filed by the education department before the learned single judge. 16th July. Note you have to give before that. Yeah, we want an explanation on this.
That is clearly not applicable. I will satisfy. I will satisfy. Yes, yes, fine. I will satisfy.
Mention here. 6 weeks from when? 16 July.
16.
Yes, 16.
15 Nikki?
Sir.
No.
ঠিক আছে ঠিক আছে বলিয়া বলিয়া ঠিক আছে ঠিক আছে ঠিক আছে
I'm so obliged.
For hearing, item 46 to 48.
In the OBB case also, I'll find my.
Please.
Item 37.
Please, we have said Mr. Chaudhary and Mr. Das.
Yes, yes.
We can do this, huh?
Mr. Chaudhary and Mr. B. Das, senior. We have said Mr. Das also.
And at item number 46, can I pray for little accommodation today? I couldn't go through the brief.
Not difficult. Jolha.
So Lamla is an interesting matter, my lord.
It is an interest.
We have been taken out.
Constitutional matter, whether it can be taken. We'll take interest.
Oh. Yes, affidavit. Oh, state or affidavit file is on. File. Affidavit has been filed.
All right, when do you vote?
My lord, the middle of June, my lord.
Middle of. As prayed for, on behalf of the petitioners, let this matter come up for consideration on. You choose a date for June.
My lord, could it be on, my lord,
It's a very simple matter.
23rd of June, my lord?
23rd of June, involving Article 335.
Yes.
Nothing beyond.
Nothing.
And it is
And
all.
recently, my lord, the scope has been enlarged. Let us see
It is
where we
always,
fair.
the number, it has to be updated always.
Yes.
Because Cholha being brought from MOBC to OBC, there must be some statistics to support that.
That is what is missing, my lord. That empirical data is not there. That is our case.
The Bihar rule.
Yes.
Bihar rule before SAR. I mean, that's a judgment of the Supreme Court. That's a judgment of the Patna High Court affirmed by the Supreme Court.
Yes.
Bring that also.
Okay.
Item 53.
My lord, item 53, my lord, it's more of a mercy petition, my lord. What had happened?
Look here.
Instead of my lord 20,001, I quoted 2 lakh 1.
No. Mr. Chaudhary.
Yes.
Prima facie, if the rates would have been somewhere around 20,000 per metric ton or 25,000, the rates for all these years have been more than 1.5 lakhs. So why should it be understood as a?
I immediately sent a mail. I sent a mail saying that something is wrong.
You may have done that, but look at the logic of the learned single judge.
Yes.
He says that he examined all the rates erstwhile, I mean, in later days also. See, the amount is 40 lakhs, no?
Lord, all that we are saying is whatever are the expenses, please deduct it and approach 40 lakhs, 38 lakhs. Lord, please come to page 80 for a moment, Lord. Page 80. Same day, my lord, I informed.
That has been noted.
It is to inform you that by mistake, instead of 20,001 per MT, I have quoted 2 lakh 1 for the lot 1 against the auction number.
Power Grid Corporation. You are appearing for Power Grid Corporation.
Yes, madam.
Why do you keep this money?
No, my lord, actually, yes, the condition of the tender, my lord. The amount
No, but immediately the mistake was pointed out that they wrote.
But that's not the correct position, my lord. Immediately, when the amount is entered into the system, my lord, the amount cannot be changed, my lord. Before entering into the system, he was asked whether he has confirmed the amount. He has confirmed the amount, my lord. Therefore, the amount was entered in the system, my lord. Once the matter is entered in the system, the figure cannot be changed, my lord.
Mr. Chaudhary, you show us some judgment of the Supreme Court. We have also, this court also has done it.
Right.
We have directed the FCI to return.
Okay, I'll find out.
And then we say that this unjust enrichment, notwithstanding the riders in
Yes,
the NIT,
yes,
we have said so.
yes. I'll find out.
We have also passed the judgment.
Some
We have
other
passed
day,
the
I'll find out the judgment of some High Court.
But because of this,
Sitting in
action,
Assam, we have passed it now.
Okay.
corporation,
the amount
not only
was
the
less.
corporation has suffered the amount that today 4.1 crore, my lord. Or the corporation has suffered a loss, my lord, because of the difference.
This entire lot was lifted, my lord. There's nothing like it.
Subsequently, it was, but they my lord.
Entire material was later sold in a subsequent auction without loss to the respondent.
Yes.
That's the statement made.
Right.
You have to deny this. Have you filed your response?
No, not yet.
You file your response. In fact, we are inclined to find out some way of returning the amount. You know, there is a difficulty.
Well,
This immediately he says,
no.
Now, anything there in the NIT.
Not kindly,
this is
kindly, I
something-
draw you lots of.
You're a big corporation. You
Who are you?
can't
Who are
act
reply,
like
my
this.
lord? Who are
And it's a
reply?
code of equity also.
Judgment
my
court ka laiye.
Unlike.
You must respond.
Well,
Mr. N.C. Das, Leonard, senior advocate. Mr. N.C. Das, Leonard, senior advocate appearing for the power grid SLCO.
Okay, deep level.
This case involves a dispute over e-auction for scrap materials conducted by MSTC Limited on behalf of the respondent / Power Grid Corporation of India Limited. The appellant participated in the online auction, but there was a typographical error in his bid price. Instead of quoting his bid at rupees 20,000 per metric ton, it was entered as rupees 2 lakhs per metric ton. No sooner the mistake was noticed, the authorities were informed by email on the same day before the auction closure. A request was made for correction or cancellation of the bid on grounds of bona fide mistake. The claim of the appellant is that despite this communication, the MSTC accepted the bid at the erroneously placed at the higher rate, issued a sale intimation letter, and later forfeited the pre-bid earnest money deposit of approximately rupees 35 lakhs, of approximately 34.5 lakhs, when the appellant failed to pay the balance amount, which was based on the bid where there was a typographical error. The challenge to the aforenoted decision of the respondents failed before the learned single judge. Failed before the learned single judge. The learned single judge ratified the stand taken by the respondents that once a bid is submitted and confirmed on the portal, it cannot be withdrawn or modified, even for genuine mistakes. This rigidity is for maintaining transparency and finality in the e-auction process. The claim of the appellant is that the logic employed by the authorities, as also by the learned single judge, is incorrect, or at least debatable, especially in the background fact of the price wrongly quoted by the appellant to be unrealistically high compared to the market value. The appellant also claims refund of that amount after all necessary deductions are made on grounds of equity. A contention has been raised on behalf of the appellant that the materials were later sold in subsequent auction without any loss to the respondents. Mr. Das, learned senior advocate appearing for the Power Grid Corporation, however, disputes the aforenoted factual position and submits that necessary response affidavit shall be filed on his behalf by the next day. Re-notify. We are not very happy in your pocketing the amount. You can deduct necessary materials. All these conditions in NIT. You see, don't have to be so rigid. What losses? You don't take a call. Because otherwise the authorities in the Power Grid Corporation would face the music. We will pass an order in case we find some precedent.
Well.
And in fact, if I remember correctly, in fact, we sitting together, we have passed an order for refund. Based on Supreme Court decision, the equity starts where the law ends. Equity starts where the law ends. Now, we are not asking you to return the entire amount. Let us see. We are not asking you to concede. We will pass an order.
No.
Asking for concession from a corporation which has pocketed 40 lakhs would be difficult.
Now for that only just for a moment, my lord.
That's the way you respond. You respond. When we have said that it is a matter of equity, then we will not go into all these details. The question is, when does equity begin? There is a dispute. So we'll see what is to be done. Re-notify school in July. July. Find out
21-7.
the judgment of the Supreme Court and our judgment.
Lordship, the other High Court judgment was quoted in the judgment itself. And Lordship, when one minor error is 20,001 rupee.
20,001. One we have. It is not a mistake. It is deliberate.
No, Lordship.
Only for the sake of flow. 20,001 is what? And 2 lakhs 20,000. Let it remain.
Yeah, that will be my below this my lord, reserve price, my lord.
Oh, 20,001 and 2 lakh 1. Correct.
That's right. Deeply older.
21-7.
Mr. Das, you have given us another clue. So this was the basic reserve price.
No. There was no reserve price. There was no reserve price. There was no reserve price. I can show on record.
And it was, you have quoted the basic reserve price.
It started out, in fact, the records will show it started out with something like 20 rupees, 40 rupees. Started that way. So that way. That was the records will show the earlier. The records will.
I am holding this up for my lord.
No. Reserve price was not there. And in fact, no, NIT did not say about any reserve price. See?
21-7.
21. Deeply obliged.
Item 54.
In this matter, my senior MK Chaudhary is having some difficulties.
Well, he was here, Mr. Chaudhary.
Yes, due to some difficulties, we have to leave later.
As prayed for on behalf of the appellant. On account of unavailability of Mr. M.K. Chaudhary, Leonard Senior Advocate, who is to address the present unavailability of Mr. M.K. Chaudhary, Leonard Senior Advocate, who has to address this court. Let this matter come up for consideration sometimes in June 1st week.
11 June.
Next, we'll
Item 55 and 56.
for a while. Then the basket. Where is Mr. Chanda?
My lord, I made it.
So you are here. All right. I'm so sorry.
No, it's all right, my lord.
Not even the one thing, matter is to claim of great pay, Lordship. I want to find a short 2-3 pages written.
Can you not argue it today? We are through with the other matters. We have plenty of time today.
Lordship.
Let me. We'll reassemble at 12. In the meantime, you formulate your arguments and we'll deal with it. What is your name?
My lord, this is you, Dutta.
You are appearing for all the respondents.
Yes, my lord.
All right.
Mr. Chanda is also there, my lord.
It's all right. We just need appearance of representation of the respondents.
Much obliged.
Advocates do not matter much.
No, what?
Assistance matters.
55 and 56.
We can put. Yes.
Lordship, the matter relates to the claim of great pay of rupees 4,200.
Give us 2 minutes. Yes. Yeah, Supreme Court also. Page 143. Yeah. Yeah, no problem, bench. I worry. Yes, Mr. Chakravarti.
Lordship,
I think the issue has been decided.
Lordship, but Lordship, may can they come, their claim is based on the.
Can we go beyond that? You
Can
tell me,
we-
we will decide everything. That you can ask us to decide on any issue. But the matter was decided by a particular bench of CAT affirmed by Supreme Court. Therefore, we are bound by the Supreme Court judgment.
Lordship, one aspect, three aspects that has not been taken into consideration. One, Lordship, their claim is based on.
But the question remains that whether they were entitled to the grade pay of 4,600 and therefore in the next grade pay 54.
In our humble in my humble submission, they are not, because Lordship. Lordship, their claim arises out of this OM dated 13/11/2009, which is at page 136, Lordship. And the point, Lordship, number 3, it says that they must be in the pre-revised scale of 6,502.
Now, we will not get into that now.
But they were not in that scale. We have stated in our written statement, Lordship.
That means nothing.
Had they been, Lordship, they would have done that.
Verifying the individual service particulars of the appellants. Make an order. There's nothing which we can do in this.
Lordship, even the service rule says that junior Hindi translator should be in the grade pay of 4,200.
No, sab sunte, the Supreme Court would not have affirmed. We don't wish to change our track.
All this matter has not been brought earlier.
क्या करेंगे? क्या करेंगे? Tell us whether we have any other option.
Lordship, because the Ministry of
Tell
Finance.
us we have any other option. Go before the Supreme Court.
Lordship, Ministry of Finance also stated so, Lordship, in clarification.
From going to Supreme Court, go to Supreme Court. Yes.
My lord, what they are submitting that they were not in pre-existing pay scale, required pay scale, but that is also not true, my lord. They have already in 6,500, 10,500. They were that is not
correct. Dismissed.
Much of.
We have heard so and so. Dismissed. Probably, Mr. Chakravarti, you knew about.
Item 63.
Lord, my sincere apologies, my lord, for not being available in the morning as well as in the last two hearings, my lord. Unfortunately, I was caught up in a part-heard matter, my lord.
Doesn't matter. Doesn't matter.
Full for being accommodated, my lord. I will not take more than 2 minutes by clock, my lord. 120 seconds maximum.
Yes.
My lords, may kindly have the effective order of 24th February 26. (24th February 26) order passed by my lords.
Yes.
the second last page, my lord, page,
Yes.
internal page 6, just the last line, if my lord would read with me.
Yes.
We therefore, my lords have it?
Yes. Yes.
We
Yes.
therefore, in all fitness of the things, seek an information from the state whether the candidature of the appellants could be considered against those vacant posts, if not already filled up. Please mark this, my lord, one line, if not already filled up. Then please see the second part also, very, very important. If the appellants otherwise would have qualified, but for their essential certificate of B.Ed degree not having arrived at the appropriate time. So there were two information that my lords had sought from the state. One, if they are vacant posts from the earlier recruitment. Second, leaving aside the fact that my degree, which I had already given them a representation, arrived late, if that is kept aside, would I be eligible to participate and get this? So these were the two information. After this, the matter was listed twice for the state to respond. They gave some affidavit, etc. My lords did not entertain it, saying that please give these two information. Now, please see the final affidavit to this that they have filed, my lord. Kindly have the affidavit in opposition. This would be at my lord's file, starts at page 239. 239 it starts.
Yes.
In this, if my lord would kindly come to page 241. 241, para 5. May I read para 5?
Yes.
That during the process of document verification, it was detected that the appellants had acquired their B.Ed qualification only after so and so. That is subsequent to the last date prescribed for submission of online applications. As such, on the relevant cutoff date, the appellants did not possess the mandatory professional qualification required under the advertisement and the governing statutory rules. Consequently, the candidature was rejected as being so and so. And then please see 6 also, was very, very important. This para 5 is the answer to the second question in which in my humble submission, which is not correct. Please see para 6, but then the answering respondent humbly begs to state that wide advertisement dated so and so, all total so and so posts of so and so were advertised, and out of which 657 posts could be filled up. The remaining 1659 posts could not be filled up due to less marks obtained by candidates in the recruitment test than the cutoff marks, and also due to non-fulfillment of other criteria mentioned in the advertisements. And please see para 7. This is also very, very important. That the answering respondent most respectfully submits that although so and so posts are lying vacant pursuant to the selection process, the candidature of appellants cannot be considered against the said posts, as they did not possess the requisite qualification as on the last date of the submission of applications. It is submitted. We can just ignore that, my lord.
No,
Just
read that. It is
Very
submitted.
good. It is submitted that any such consideration would confer an undue and impermissible advantage upon the appellants. Moreover, several other similarly situated candidates who acquired the essential eligibility qualification after the prescribed cutoff date were either not considered or consciously refrained from applying in adherence to the eligibility conditions stipulated in the advertisement. In such circumstances, entertaining the appellant's candidature at this stage would result in unequal treatment, violate the principle of a level playing field, and render the selection process discriminatory and legally unsustainable. Now, if I may, my lord, just one more minute. If it doesn't, would my lord want me to read any other part? This is what I felt was. So, my lord, the direction of this honorable court was twofold. In fact, threefold. One, is there a vacancy? Second, has that vacancy been carried over to the next recruitment, because the next recruitment also came out? Third, if aside, leaving aside that my certificate, because of reasons unknown to me, came late, for which I'd already given them a representation, would I be eligible or would I qualify? In my understanding, my lord, most respectfully, I will submit, it is not their case that I am not in merit. Please bear with me. The marks that I have obtained, my lord, all of us, are much more than the people who have been appointed. Ultimately, my lords have to see about the quality of education being given to children under the Right to Education Act. So there is no loss on merit in any manner. There is no loss on quality in any manner. Third most important thing, my lord, as per the advertisement, with prior to 7 days, the advertisement said, and the rules still say, they may say that they have changed protocol, amended the advertisement, but the rules stay intact. The rules have not been modified. And if there is a conflict, my lords are well aware that the rules will prevail over the advertisement. Unless those people which they are now saying will not have a level playing field, they never applied and sought a relaxation. Even till today, my lord, as I argue, 2 years later, my relaxation representation has not been rejected. And that was my ground. So therefore, my lord's mandate was very clear in my humble submission that one, do you have vacancy? Second, has it been carried forward? Third, leaving aside the fact that it came late, would I be considered or can I be considered because whether I fall in the merit or not? In my humble submission, my lord, the first two answers have been given that it has not been carried forward very fairly. It has also been stated that yes, posts are vacant. Third is to my favor to say that the candidates are below cutoff. Now, I am a person who's above cutoff. And lastly, my lord, just 30 more seconds. This is not the first time that state has given relaxation for reasons beyond the control of the petitioners. It has been always, I have annexed that in the writ appeal. I don't want to trouble my lords with the merits. Every time the state themselves have given relaxation that if you are appearing and if the university delays, then we will accept. So therefore, my lord, this may not be seen with the regular four corners of the service laws, my lord, is what my humble submission is. Because as a matter of fact, the quality of education to the children needs to be seen. And if I am higher on merit, I have scored more marks, undoubtedly I'll be a better teacher than the persons who are lesser in marks and have been appointed. So, my lord,
All right, Mr. Khatnia,
Yes,
what do you have to say to this?
that issue has already been decided, my lord. One. Page 187. My lord has already decided that issue, my lord.
Page 187 is what?
This is an order passed by my lord. In similar situation. My lord, kindly come to page 190. The relevant portion. The paragraph start with the short issue which arises in this appeal is whether the appellants could have been allowed to cure the defects, especially in view of the scheme of the examination when at the time of verification the documents had to be produced regarding eligibility. The submission raised on behalf of the appellant is not justified. It is right that eligibility for participant in a recruitment process has to be determined with reference to the cutoff date stipulated in the advertisement, namely the last date of submission of application unless the rules provide otherwise. The rationale is twofold. First, to ensure fairness and level playing field by treating all aspirants alike. Second, ensure administrative certainty so that the authority may freeze the field of eligibility on a given date. If candidates who were ineligible on the last date are allowed to acquire qualifications subsequently and yet participate, it would amount to confer upon them an undue advantage, while others similarly placed but who refrain from applying would stand unfairly excluded. Then, my
That's all
lord,
right, but how about are these 1650 or 1659 posts that
yes,
remained vacant? That was also carried forward.
that was still
Second recruitment exercise.
no, my lord. Thereafter there was no recruitment, madam. Those posts are still vacant, madam.
Would you consider if they have age, if they run out of their age?
No, my lord. They are all around less than 30 years, my lord.
No. If these persons,
Yes, my lord.
if these appellants, if they have no age left, would you grant them concession in the next recruitment?
Yes, madam. In that case, no difficulty because
record your state.
Yes, madam, because I have seen that, madam, from a cost ideal, all are below 30 years, madam. So here, madam, it's a 38 years.
36,
38
in
years.
case 38 years.
38 years in Assam, madam.
All right, consider the cases in case we decide. All right. Arguments heard. Post for judgment on post for judgment on Friday, 10:30.
But just 5 seconds, if I can take the order that was read by Mr. The Learned Counsel for the State.
That's in a
Court.
different case.
Yes, that went to the Supreme Court and it was withdrawn, my lord, with liberty. So it will not really apply.
Correct. And the logic, what he is referring to the logic which we have said.
But the representation was never in that case.
We will try our best to.
I'm so grateful, my lord. That is the best assurance I can get, my lord. I'm so grateful, my lord.
All right. Yes.
Deeply grateful, my lord.
Thank. On 15. On 15, Pala case.
I'm so deeply obliged, my lord. Deeply grateful.
All.